Welcome to a little chat about some estate planning that everybody should have in place. So don't leave home without having these documents in place. I know it's kind of hard to leave home without having anything in place, but did you know less than 50% of the population has a will? Less than 50%. And most of the people that do have a will are over 65. That means it's a much larger percent to you, the people that are watching me here on Facebook. So why is it important to have a will? If you have things, and I'm going to use wait, I've got to do my disclaimer. This is not legal advice. This is legal education. I am not giving you legal advice. I do not represent you unless you've already hired me, of course. Get it? Education. Take this. I'm only licensed in Florida, so cannot practice in other states. So here we go. Less than 50% of the population, like I just said, has a will. Now, who needs a will and what does it do? Well, a will, as I was saying, transfers your stuff. I know it's not a real legal term, but I try to speak as simple as possible. There are a lot of attorneys that don't understand the language that we use in estate planning and probate, so I really try to make it easy for everybody to understand. So a will transfers your stuff when you die to the people you choose to receive it, okay? If you're married, if you have kids, if you're single, if you don't have kids, you get to choose who gets your stuff. And you do this through a will. Now, one of the misconceptions a lot of people have is if I have a will, my family, my loved ones, my friends will not have to go to probate. And probate, as we spoke about a couple weeks ago, is the court process of transferring your stuff to the people you name in your will to get your stuff, right? If you don't have a will, the state has a plan for you. You may or may not like it. It's just how it is. If you don't have a will, you go do what the state does, wants you to do. Your stuff goes where the state wants it to go, not where you choose. You get to choose with a will. That's about the only difference between having a will and not having a will, because they both have to go through the court process of probate. Now, the court process of probate can be very expensive and timely, and it's really frustrating. Again, we talked about this a couple weeks ago, so if you want details about that, go there. So why do you need a will? If you've got kids, you certainly want to have a will. Kids under 18. So if you have minor children, you want to have a will to make sure that you name a guardian. That's somebody that will be able to take care of your kids, love your kids, and really raise them with the same values you have. And you do this with a will. So when you die, you name somebody that will take care of your kids in the same manner that you would want them to be taken care of. And you get to choose that instead of leaving it up to a judge. Very important to have a will if you have kids, if that's the only thing you have. If you don't have any property, okay, fine, but name somebody to take care of your minor children. Hopefully nothing ever happens to you until you're ripe old age and your kids are old, but we just never know. You never want to take that chance with your kids. You probably don't take your kids out without having them put their seatbelt on, or without putting them in a car seat. So why not take some time to put a will together and make sure they're cared for if something does happen to you. All right. So those are the main things a will does. What's the next thing that we need? How about a power of attorney? What is a power of attorney? So you may have heard of a power of attorney as a durable power of attorney or a power of attorney for financial reasons. A couple different terms for it, but mainly it's a power of attorney or attorney in fact. And that is a document that you name somebody to take care of your financial stuff. Okay, so anything that you can see, tangible, money, house, IRAs, 401ks, anything that you may have to It could even include being able to help pay your electric bill, or your, if you're in school, somebody can go into your school records and make sure you're doing what you need to do. One of the things we do for what I call a kids transition plan, it's, kids that are 18 to 25-ish, still, they're adults by law, but sometimes they want mom and dad's help. So we can set them up with a power of attorney, so that you can help them with their finances. You can make sure that everything is taken care of. They can, assign you to do that. Now, with all the financial issues that are there, it is a very powerful document. It can be scary because you get to act, or the person that you name as a power of attorney gets to act as you would. So they step into your shoes. Now, one of the big deals about it is they have to do whatever they're doing with your money for you, for your best interest. It's a fiduciary responsibility taken very serious by the courts and by law. So it's a big deal to create one. It's a big deal to have someone have a power of attorney for you. Okay. Now in Florida, it takes effect immediately. It does not, what we used to call springing. It does not spring into action if you are ever disabled. It takes effect immediately. So, talk to an attorney about what you should do to make sure it's not misused. All right. First of all, about misuse, you want to make sure you're naming somebody that understands finances and can help you out, or at least has some relationships or can create relationships with financial professionals to help deal with your issues. It's important to have, because if something ever happened to you and you were disabled, or I hate to say, like Alzheimer's, we're in Florida, that we've got a lot of dementia, Alzheimer's, strokes, things like that, where if you're not able to take care of your things, you've named somebody to do that, instead of having to have them go to court and get what we call a guardianship over you, guardianship over an adult, which is a very, again, costly process, takes a lot of time, and we want to avoid court as much as possible. All right. So far we've talked about the will, we've talked about the power of attorney, and now let's talk about another document that everybody should have. So these are 3 documents that everybody should have: a healthcare power of attorney, or in Florida, we call it a designation of healthcare surrogate. Just depends on where you are, what they're going to call it. And that is naming somebody to help with not with financial decisions, that's the power of attorney. Naming someone to help with healthcare decisions, all right? So if you're, a lot of us live in South Florida, a lot of people I know live in South Florida, I live in South Florida, and even if you live all the way up north in Florida, 95 goes all the way through it, and people drive a little bit crazy. There's an accident every day on 95. So if you've got an interstate like this, or if you drive, it's really important to have these documents in place, because if you're in an accident and you're unconscious and they take you to a hospital, and they of course keep you alive, but if there's a operation or a procedure that it could go either way, it could be like, we can amputate his leg or we can keep it. If we amputate it, he gets a prosthesis, he's going to do physical therapy for so long and probably be okay. If we keep it, it's going to do physical therapy for 3 to 6 months and probably still be suffering. It's going to be painful, may never get full use of his leg. What do you want to do? So you want to have this conversation. I know it's a fun conversation to have, right? But you have the attitude like I do, and I want that cool prosthesis. Yeah, I would never wish that on anybody or myself. But if it happened, my wife knows, hey, just get him the cool leg. He'll be fine with it. And that's a conversation that not everybody wants to have. Not everybody wants to have a conversation about death, because it is a little bit scary. I try to make it a little less scary, lighten up the mood a little bit. So have the conversation, and then it'll be better after you're done. So healthcare surrogate is going to make those medical decisions for you. All right, there are a lot of other scenarios, but that's just one that I use with my clients all the time. All right, so another part of that healthcare document is a living will. A living will, not to be confused with a will. We talked about that a while back. So a living will is what I call the pull the plug document. All right, try to be as simple as possible. Basically, you're dead, but a machine is keeping you alive. A machine is pumping your blood. It's maybe breathing for you. Vegetative state, which means you don't have any brain activity, end-stage condition, terminal condition, meaning you're at the end of a very long illness and your body's just done. And the only thing keeping you alive is that machine. It's your opportunity, once again, your opportunity to tell your loved ones, I want to go. I do not want to be left on a machine. I do not want people coming in saying, oh, they look so great. Your opportunity to say, no, pull the plug, let me go. Turn the machine off, turn life support off, and let me go. If you are the opposite and you want to be left on life support, that's where you say that, all right? So you get to determine what happens to you. It's really important because sometimes family members get emotional, okay? Most of the time, family members are emotional around those times. And they don't want to be the one that kills mom or kills dad by saying, yes, pull the plug. So when you do it, you're giving them permission to have peace of mind that they've followed your wishes, all right? Really important document that, again, everyone should have. So how about avoiding court? How do we avoid that probate? We do that with a trust. You may have heard of a living trust, a revocable trust, a revocable living trust, irrevocable trust. There are a lot of different kinds of trusts, but most people would use what we call a revocable trust or a living trust to avoid probate. And this is a document that makes it so that all your assets are owned by the trust. Okay, you've heard of trust before probably, but you probably thought it was only for the really, really rich people. Well, it's not. It's really for everybody that has real estate, or everybody that has some assets, and children. Okay, if you've got minor children or even children that are adults that you don't want to have a lump of money, then you can create a trust so that it's there to take care of them throughout their adulthood. You can do it as long as you want. I've heard of cases where they've said at 65 they can start getting the whole chunk. That money is there for their health, education, welfare while they're growing up. But then at a certain age, you want to give them a chunk of money, and then you can divvy it out over a few different distributions. So think of it as a box, all right? So we're putting all of your stuff inside the box. Now, you are still the one that manages it. That means you are in total control. If you want to change anything you've written inside there, you can change it. If you want to totally get rid of it, you can totally get rid of it. If you've got a couple pieces of real estate and you want to pull one out and sell it, you can do that. You don't need anybody's permission. You are in charge. And you're also benefiting from everything that's in the trust because it's yours. You put everything in, you manage it, and you benefit from it. All right? So a trust is a really powerful document that, little background noise there, a really popular document that can help your family out. It can help you out in case you're incapacitated. So let's go back to that stroke or Alzheimer's. Those assets are still there for you. They're there for your use. They're there to support you. And you've already named somebody to step into that role, just like the power of attorney, and take over for you so that you are taken care of. Okay. So the trust is how we avoid probate, as I said. And not just multimillionaires, not just the ultra wealthy, those are not the only people that need them. So if you're not sure, let me know and I'll be happy to walk you through it. Again, I'm only licensed here in Florida, so we can help you with that. The last thing that somebody might need is a designation of guardian for minor children. That's if something happened to you and you want to choose who takes care of your children, you get to do that with this designation of guardian for your minor children. Similar to the will where you name a guardian, this takes effect even if, well, even if this takes effect if you're ever disabled. So if you ever have that coma situation, if you're ever unable to take care of your kids, you've named somebody to step in and do that. The will only takes effect if you die. This document takes effect if you're just not able to. Okay, so if you are diagnosed with something and physically unable to, if you're in a coma, like I said, that's the biggest reason. It can be temporary, it can be permanent. If you snap out of it and you're okay, then fantastic. Then of course you would be able to regain control of your children. So not an easy conversation to have, but as long as you know that there are documents out there, and once we get them in place, you don't have to worry. We give you peace of mind. We really set it up so that you are taken care of for your life and long after you're gone. Your kids will be taken care of. You won't have to worry about them. And everybody's got peace of mind. Everybody's got an understanding that they're not going to have to deal with the court system as much as they would if you don't have a plan. Or remember, if you just have a will, you still have to go to court. So if anybody's got any questions, please ask in the comments below.